The email arrived at 4:17 p.m. on a Friday, which is the corporate coward's favorite time slot. It allows the sender to scurry out to their Tesla and hit the freeway before the recipient has time to process the rage. Subject: Compensation Review Q3 Adjustment. I did not open it immediately. I let it sit there, bold and unread, pulsing like a migraine in the center of my Outlook monitor. I took a sip of my lukewarm green tea and looked around the open-plan office of ZephyrStream, a mid-sized software company in Silicon Valley. To my left, the sales team was playing frantic ping-pong, high-fiving over a deal I knew they had structured incorrectly. To my right, the marketing interns were filming a video about hustle culture. I am Gavin Miller. I am 49 years old, and I am the Senior Contracts and Intellectual Property Analyst. That means I am the person who reads the 400-page documents that the sales executives sign without looking. I make sure we do not accidentally sell our source code to a shell company. I am the invisible guardrail on a highway full of drunk drivers. I click the email. Hi, Gavin. Thanks for your patience regarding the compensation adjustment request. We have reviewed your performance metrics, which remain stellar. However, due to current reallocation of Q3 liquidity into strategic acquisition channels, your raise got lost in legal. We simply do not have the approval code to push it through this cycle. Let us revisit next quarter. Best, Justin Cross, HR business partner. Lost in legal. I stared at the phrase. It was a lie so lazy it was almost insulting. I am legal, or at least I am the backbone of it. The general counsel, a man named Nigel Brooks, who spends 80% of his time golfing and the other 20% asking me how to convert PDF files to Word documents, would not know a budget approval code if it bit him on his Callaway polo shirt. This was the third year in a row. 3 years ago, it was pandemic uncertainty. 2 years ago, it was market volatility. Now it was lost in legal. Meanwhile, I knew for a fact that Justin in HR had just approved a $15 Zusen retention bonus for a junior developer who had broken the build server twice last month. I knew this because I processed the NDA paperwork for those bonuses. I did not scream or type a reply in all caps. I am a professional. I simply took off my glasses, cleaned them, and felt a cold switch flip in the back of my brain. It was not anger, really. It was clarity. They thought I was furniture, a sturdy, ergonomic chair that you sit on and forget. They assumed that because I was quiet, because I did not play ping pong, because I did not wear fleece vests and shout corporate slogans when I closed a ticket, that I had no leverage. They were wrong. I looked at the sales team again. They were celebrating the Vanguard Defense Logistics account. It was our crown jewel, an 80,000 joint venture with a massive defense logistics firm. It was the deal that paid for the CEO's new glass-walled office. It was also a deal that I had written. Not the glossy pitch deck, but the actual contract. I wrote the master service agreement, the intellectual property indemnity schedule, and the 60-page addendum on royalty structures. I remembered that addendum vividly. I wrote it 3 years ago late at night when the company was desperate and cash poor. We needed Vanguard to sign, but we could not offer them the upfront equity they wanted. So, I had crafted a performance-based royalty trigger. It was complex, and it was buried in legal terminology that made your eyes bleed if you did not know what you were looking for. I stood up and walked past the ping-pong table. One of the account executives, Hunter Smith, yelled at me to smile because it was Friday. I gave him a thin smile and walked to the secure file room. Most things were digital now, but the original Vanguard contract with the wet signatures was kept in the fireproof safe. I had the code. Of course I had the code, since I was the only one who ever went in there. The room smelled of ozone and dust. I spun the dial on the heavy steel cabinet. Click, click, clack. I pulled out the navy blue binder labeled Vanguard Licensing Agreement Executed Copy. I opened it to page 42, clause 14C. I ran my finger over the text. The font was small and deadly. In the event that the licensor ZephyrStream achieves 3 consecutive quarters of 99.99% uptime while processing in excess of 5 terabytes of client data, the milestones. Licensor acknowledges that intellectual property rights for the core algorithm shall shift to a shared royalty model, entitling the original intellectual property architect to a retroactive commission of 0.5% of gross contract value unless a waiver is signed by said architect. I checked the signature page. signed by the CEO of Vanguard, signed by our CEO Grant Baldwin, and on the bottom line, under IP architect and drafting analyst. It was signed Gavin Miller. I closed the binder. The silence in the file room was full of potential energy. Lost in legal, I whispered. My raise was not lost. It was right here, hiding in plain sight, compounding interest for 3 years. I was not going to reply to Justin. I was going to teach them a lesson about the importance of reading the fine print. I slipped the binder into my bag. Taking original documents is technically a violation of company policy, but then again, so is wage theft, and I had a feeling that by Monday morning, company policy was not going to matter much anymore. I spent the weekend in my home office, which is the exact opposite of the corporate headquarters. It is quiet, organized, and free of ping-pong tables. There is only an efficient espresso machine and a gray cat named Oliver who judges my life choices from a sunbeam on the rug. I had the physical contract, but now I needed the hard data to back it up. Clause 14C was a dormant trigger. It relied entirely on performance metrics. If the company performed poorly, the clause was worthless. If the company did exceptionally well, the clause woke up and demanded to be fed. I logged into the admin dashboard of our data warehouse. My access level was essentially God mode. This was not because I was a hacker, but because 5 years ago, our former chief technology officer got tired of manually approving my audit logs and just gave me root access. He forgot to revoke it when he left. People tend to forget a lot of details about a quiet contracts analyst, and this was one oversight I was glad they made. I pulled the uptime reports for the last 24 months. The numbers were clear. In the first quarter of last year, we hit 99.992% uptime. The second quarter came in at 995%. The third quarter reached 99.998%. There it was, 3 consecutive quarters of near perfection. I remembered those months clearly. The engineering team had lived on energy drinks and slept under their desks. I had personally ordered 70 pizzas to the office during late-night coding sessions. The CEO had bought himself a new sports car to celebrate the achievement, while the team received a $50 coffee voucher. Next, I looked at the process client data volume. It showed 12 terabytes, 15 terabytes, and 22 terabytes for those quarters, which easily crossed the 5 terabytes milestone threshold. I sat back in my chair, the blue light of the monitors reflecting in my glasses. The arithmetic was straightforward, but the financial implications were massive. A commission of 0.5% on the gross contract value of the Vanguard deal, which was valued at $80,000, came out to $400,000. Adding the retroactive penalties for failure to notify and the statutory interest, we were looking at over $480,000. I had written Clause 14C as a protective measure to ensure the original intellectual property creator would not be cut out if the company was sold or grew rapidly. In their corporate arrogance, the current executive team, most of whom were hired long after the contract was signed, had never bothered to reread the legacy agreements. They treated the Vanguard deal like a cash cow, completely unaware that the fence around it was highly electrified. On Sunday evening, I sat on my patio with a glass of Cabernet. I did not call my own lawyer yet. Instead, I called the one person who would understand the strategic leverage of the situation immediately. I called the opposing counsel. In our world, the opposing general counsel is not really your enemy. They are a sparring partner, and if you are both good, there is a deep mutual respect. I dialed the number for Owen Stone, the general counsel for Vanguard Defense Logistics. He was a veteran attorney who had negotiated complex treaties for defense contractors, and he terrified our CEO. Owen answered on the second ring. His voice sounded like expensive scotch. He asked if the servers were down or if I was quitting. I told him neither, and that I was simply doing some housekeeping. I explained that I was reviewing the master services agreement we executed 3 years ago, specifically the royalty addendum. There was a heavy silence on the line. I heard him shift in his leather chair. He asked if it was about Clause 14C. He knew. A lawyer of his caliber had undoubtedly flagged that clause years ago, noting how dangerous it was for us, and let it pass because it did not harm Vanguard. In fact, if we defaulted on paying the intellectual property architect, it put Zephyr Stream in breach of vendor compliance. I confirmed that the milestones were met 18 months ago, and that the company had failed to notify or pay me and had actually just denied my cost of living raise. Owen let out a dry laugh. He noted that such negligence compromised the intellectual property indemnity shield for the software Vanguard was using. Technically, Zephyr Stream was operating the platform without a valid license, placing Vanguard's systems at risk. I agreed, telling him I thought he might want to know before I took formal action. He thanked me for the heads-up and suggested we meet for lunch the following day. We met at Elm and Ember, a dark, upscale restaurant where business deals were made in quiet corners. Owen looked like a silver-haired wolf in a tailored suit. He got straight to the point before our water arrived. He told me his team had reviewed the document and that Clause 14C was completely ironclad. He asked who had allowed me to insert it. I explained it was the former CEO, who was desperate to close the contract. Owen explained that Vanguard paid $20,000 annually for the software. If Zephyr Stream was in breach of its own internal IP protocols, Vanguard would be forced to issue a formal notice of inquiry. They would demand a full audit of all intellectual property disbursements. He slid a folder across the table containing a draft letter, addressed to Grant Baldwin, our CEO, demanding proof of compliance with Clause 14C within 48 hours. He warned me that once the letter was sent, they would search for the leak and suspect me. I replied that retaliation in California carried triple damages under employment law. I told him to send it. He agreed to send the audit demand at 9 a.m. on Tuesday morning and suggested I be in the office to watch the fireworks. Tuesday morning at 9:02 a.m., the office was buzzing with the usual caffeine-fueled chaos. The marketing team was arguing about brand guidelines, and the sales team was ringing a cowbell because someone had sold a minor subscription. Then the audit email arrived. It went directly to the CEO, Grant Baldwin, the CFO, Spencer Cole, and the General Counsel, Nigel Brooks. I monitored the network traffic headers and saw the message from Vanguard Legal enter our mail server, flagged with high importance. At 9:15 a.m., Grant forwarded the email to Nigel, telling him to handle it and not let standard compliance spam slow down the Q4 pipeline. 15 minutes later, Nigel forwarded the message to Spencer Cole, asking if we had any royalty structures and suggesting they send Vanguard some generic financial statements. Finally, at 9:45 a.m., the email landed in my inbox from Nigel. He called it Vanguard whining again. He claimed the formal request about an intellectual property audit, and Clause 14C was legacy contract gibberish, and asked me to draft a standard response confirming full compliance, adding that I should not spend too much time on it. I stared at my monitor, biting my cheek to avoid laughing out loud. They had not even opened the attachment where Owen had explicitly listed the uptime milestones. They saw the word royalty, did not know what it meant, and blindly forwarded it to the one person in the building who wrote the clause. They were literally asking the arsonist to investigate the smell of smoke. I replied to Nigel, telling him I would log the ticket in our compliance tracker, but that verifying the specific language of Clause 14C and cross-referencing it with the performance logs would take a few days. He told me to take my time. I was not going to take my time. I was going to let the clock run out. The Vanguard notice demanded a response within 48 hours, which meant Thursday morning. If we missed the deadline, Vanguard reserved the contractual right to suspend all payments pending a full investigation. I created a new folder on my encrypted drive, naming it Contingency Escalation. I dragged in the rejection email from HR, the email from Nigel asking me to handle the audit of my own royalties, and a copy of a Slack conversation where Spencer Cole joked about hiding profits to avoid paying out bonuses. I archived everything. Wednesday passed in a blur of corporate hypocrisy. I sat in meetings where Grant talked about valuing our people and presented a slide deck about our record-breaking uptime. He bragged about how thrilled Vanguard was with our software performance, while I sat in silence, knowing they were stealing from the very person who built it. I watched Nigel scroll through golf courses on his phone, completely oblivious to the ticking clock. Thursday morning arrived, and the deadline came and went. I did not send the response, nor did I draft a compliance statement. Instead, I updated the internal ticket status to pending legal review, awaiting executive sign-off. Technically, I was waiting. I was waiting for them to do their jobs. They did not. By Friday morning, the trap was set. We gathered in the disrupted conference room for the weekly finance review. The room had glass walls and uncomfortable chairs, with a loud espresso machine humming in the corner. Spencer Cole stood at the board. He was 35, wore a vest that cost more than my car, and had the unearned confidence of a man who had never faced a real obstacle. He clapped his hands and announced that the Vanguard wire transfer was showing as pending and asked if anyone knew why. Nigel Brooks suggested it was just a bank holiday and said he would ping them. Then Toby Ward, a 22-year-old junior analyst, fresh out of Stanford, spoke up from the end of the table. He mentioned looking at the liability ledger and finding a flag on the contingent liabilities tab. He noted a royalty trigger under Clause 14C accruing at 0.5% of gross contract value, explaining that the system had automatically flagged it because our uptime was so high. Spencer Cole frowned and snapped that we did not pay royalties. He looked at Nigel, who claimed it was just old boilerplate left behind by the previous lawyers. Toby persisted, saying he could not just ignore a flagged liability because of audit standards. Spencer got red in the face and barked at Toby to delete the flag and reclassify it as a system error, shouting that we were trying to scale, not find problems. I watched Toby look uncomfortable. He locked eyes with me. He knew I managed the contracts. I held his gaze with a neutral, calm expression that warned him not to get caught in their crossfire. He looked back at Spencer and agreed to remove the flag. The red error message disappeared from the projector screen. They had just committed financial fraud, suppressing a known liability in front of witnesses. I opened my notebook and recorded the time, 10:14 a.m. Spencer turned to me and asked if we owed royalties. I replied that the contract language was very specific, and that Clause 14C was signed by the previous team. I added that choosing to acknowledge the liability was an accounting decision, not a contractual one. Spencer smirked and said it was legacy junk, deciding it was zero. After the meeting, Toby messaged me on Slack, asking if I wrote the clause. I told him that if I were him, I would send an email to Spencer confirming the instruction to delete that flag, and BCC his personal address. 10 minutes later, I received a copy of Toby's email. He had secured his life raft, while Spencer and Nigel had just drilled a hole in the hull of their own ship. The weekend felt like holding my breath underwater. Vanguard had officially frozen the payment on Friday afternoon. Usually, a frozen wire of that size would trigger immediate alarms across the finance department. But Spencer Cole had left the office early for a networking retreat in Napa Valley. The accounts receivable team saw the pending status, emailed Spencer, received his out-of-office automated reply, and decided it was a problem that could wait until Monday morning. It was a perfect corporate storm of neglect. On Saturday morning, I met with my personal attorney, Fiona Thorne. She was a sharp, formidable litigator who operated out of a modest office in a suburban strip mall, but her reputation for dismantling corporate counsel was well known. I laid out all the evidence, the physical contract, the emails denying my raise, the timeline of the ignored Vanguard compliance notices, and my detailed notes from the Friday meeting where Spencer had ordered the deletion of the financial flag. Fiona read through the documents with a steady, clinical focus. When she finally looked up over her glasses, she smiled. She remarked that the executive team was incredibly stupid, though I corrected her, explaining they were simply too arrogant to believe rules applied to them. She explained that by failing to pay the intellectual property architect, the software license was revoked, meaning Zephyr Stream was committing copyright infringement under Title 17, United States Code, Section 106. Furthermore, because Spencer had ordered the deletion of a known financial liability to hide it from auditors, they were in direct violation of the Sarbanes-Oxley Act under Title 18, United States Code, Section 1519, which carries severe penalties for destroying or altering financial records to obstruct federal investigations. Fiona drafted a formal letter of representation and a whistleblower complaint addressed to the Human Resources Department. She instructed me not to send it yet. The strategy was to wait until Vanguard officially filed its lawsuit. The moment Vanguard dropped the hammer, I would submit the whistleblower letter to HR. This would legally freeze them, preventing the company from firing me because doing so during an active investigation into the very topic of the lawsuit would constitute unlawful retaliation, making me legally untouchable. On Sunday night, I could not sleep. I sat in my quiet living room, watching the shadows lengthen across the floor. I thought about the last 5 years of my life at Zephyr Stream, the endless late nights, the weekends worked for free under the guise of being part of a corporate family, the time I missed my nephew's graduation because our servers crashed and I had to review emergency vendor contracts. I had given this company everything, and they had refused to grant me a basic cost of living raise. Your raise got lost in legal, I whispered to the darkness. It was no longer just about the money. It was about dignity. It was about the fact that they looked at me and saw nothing. Tomorrow they were going to see exactly who held the keys to their survival. I laid out my sharpest dark suit for Monday. I wanted to look professional, precise, and entirely composed. I checked my corporate email one last time before bed. There were no messages from Spencer or Grant. They were still sleeping peacefully, dreaming of stock options and luxury retreats. Monday morning arrived. The monthly all-hands meeting was scheduled for 8:45 a.m. in the main break room, which featured a raised wooden stage. The room was packed with employees holding paper cups of coffee, looking tired and disinterested. Grant Baldwin stood on the stage under the bright lights, wearing a casual t-shirt beneath an expensive designer blazer. He was pacing back and forth, shouting into a wireless microphone about how this quarter was looking incredible and how Vanguard was expanding, projecting a 20% growth trajectory. I stood at the back of the room, leaning quietly against the wall near the double exit doors. I checked my watch. It was exactly 8:52 a.m. The heavy double doors at the back of the break room swung open. It was not a late employee scurrying in. Two men in formal dark suits walked into the room, their expressions grim and businesslike. Behind them walked Owen Stone, looking tall and resolute. The room began to quiet down as a ripple of confusion spread from the back to the front. Grant stopped speaking mid-sentence, looking annoyed. He squinted against the stage lights and asked if he could help them. Owen walked straight toward the stage, ignoring the crowd. He looked directly at Grant and asked if he was Grant Baldwin. Grant nodded, asking who they were. One of the suited men stepped forward, holding a thick stack of legal documents bound by a heavy clip. He handed them to the CEO and announced that he was being served with a civil lawsuit for breach of contract, copyright infringement, and willful financial non-compliance on behalf of Vanguard Defense Logistics. The break room fell into a suffocating silence. The hum of the espresso machine seemed to grow louder. Grant Baldwin laughed nervously, looking around the room for a hidden camera, and asked if this was a joke. Nigel Brooks pushed to the front of the stage, demanding to know what was happening. Owen cut him off immediately, stating that the audit deadline expired Thursday, and Zephyr Stream failed to respond. He explained that Vanguard was terminating the contract for cause and seeking $120,000 in damages for using unlicensed intellectual property. Spencer Cole squeaked from the side of the stage, asking how they could terminate an $80 million contract. Owen replied that it was no longer an $80 million contract, but a federal lawsuit for copyright infringement and fraud. He added that Vanguard had reason to believe the executives had willfully suppressed known liabilities regarding the IP owner's unpaid royalties. As Owen spoke, his eyes scanned the room until they found me standing near the exit. I did not run, and I did not look down. I simply adjusted my glasses and held his gaze. Grant grabbed the legal papers from Nigel and flipped to page 42, scanning the text of Clause 14C. He muttered that Zephyr Stream owned the intellectual property. Owen corrected him, explaining that they only owned it once the royalty milestones were satisfied, and since they had failed to pay, the software license was currently invalid. Nigel gasped, whispering the words cost of living adjustment. He looked up, his eyes wide with sudden, terrifying comprehension, and stared directly at me. Every head in the room turned. 200 employees followed Nigel's gaze to the back of the room. I did not hesitate. I walked forward, and the crowd parted for me like the Red Sea. I walked right up to the stage. Grant looked at me, his voice trembling as he asked what was going on. I looked him in the eye and told him that my raise had just been found illegal. I pulled the envelope containing Fiona's representation letter and whistleblower complaint from my pocket and handed it to Nigel. I told him I believed it belonged to him, then turned to Owen and suggested we move to a conference room to begin negotiations. Owen smiled and led the way. Behind us, the silence in the break room shattered into utter chaos. 10 minutes later, we were seated in the boardroom. On one side sat Owen and myself. On the other sat Grant, Spencer, and Nigel. In the middle of the table lay the thick stack of lawsuit papers. Grant looked pale and physically ill. He pleaded with me, promising they could fix the situation, unlock the raise, and make it retroactive with a 10% bonus. I let out a genuine laugh. I told him we were far past a 10% raise and asked if he even understood Clause 14C. Spencer shouted that it was sabotage, claiming I had hidden a loophole in the contract. Owen intervened, pointing out it was a standard protection clause that their company had signed, triggered by hitting milestones, and ignored when formal notice was served. Nigel pleaded that they did not know because I had not warned them. I reminded Nigel that I had sent him an email on Tuesday regarding the Vanguard audit, and he had instructed me to take my time and focus on the merger instead. Owen explained that they owed me approximately $482,000 in back royalties and interest, and that because they had instructed their staff to delete the financial flag, the officers involved were facing personal criminal liability under federal securities laws. Spencer went completely silent, realizing Toby had documented the instruction. Grant asked what I wanted to make the lawsuit go away, noting that losing Vanguard would destroy the company. I slid our term sheet across the table. The demands were simple: immediate payment of all back royalties, totaling $482,340 funds, a formal apology, reinstatement of the royalty clause with penalty multipliers, full reimbursement of my legal fees, and an immediate promotion to Director of Strategic Compliance and IP Governance, reporting directly to the Board of Directors. Furthermore, I demanded the authority to audit all executive expenses. Spencer's eyes widened in panic, knowing what my audit would uncover. I gave them a choice: an internal audit by me or a federal audit during the court discovery process. Grant slumped in his chair. For the first time in 5 years, he actually looked at me. He did not see the quiet analyst in the gray cardigan anymore. He saw the person who held his entire future. He whispered that they would sign. The documents were executed immediately. The wire transfer hit my account on Wednesday morning, showing a balance of $482,340.12. But the money was only the beginning. The board of directors heard about the near miss and placed Grant in a timeout, stripping him of day-to-day authority. Spencer was terminated for financial misconduct and escorted from the building by security. Nigel remained, but he became a cooperative ghost, signing whatever compliance documents I placed on his desk. I moved into the corner office with a view of the bay. I hired Toby as my senior analyst, establishing a strict protocol of reading every line of every contract. 6 months later, I received an email from Justin in HR, confirming my new executive compensation package was approved without issue. I smiled, took a sip of my expensive tea, and replied, telling him to make sure he filed it correctly this time, as we would not want it to get lost in legal again. I closed my laptop as the sun set over the valley. The devil is in the details. They say, but they are wrong. The devil is in the person who reads them, and he had just won.